It's time for your deposition. You brought a medical malpractice case against your doctor claiming that he was careless. And now the defense attorney, as part of the first few questions that you're asked, turns around and says, "Hey, Mr. Jones, what records did you review in preparation for today's questioning?" Do you have to answer that? Do you have to share with the opposing lawyer exactly what it was that you reviewed? And if you do share that, what's going to happen next? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So here's the scenario. You sued your doctor claiming that his carelessness caused you harm and injury. A medical expert has confirmed that you have a valid basis for a case. And now, during the course of your lawsuit, there will come a time where you will have to answer questions by the defense lawyer, by the lawyers who represent the various doctors and hospitals whom you have sued. This process is called a deposition, or it's also known as an examination before trial. Now, in pre-COVID times, this would take place in our office, in our conference room. During COVID times, this will usually take place on a Zoom video call. And you will be on the call, I will be on the call, the defense lawyers will be on the call, and there will be a court stenographer on the call as well to record all of the questions you are asked and all of the answers that you give. You should know something really important. The answers that you give carry the same exact weight as if you are testifying at the time of trial, in front of a judge, in front of a jury. So the answers you give, the answers represent your sworn testimony. So now the defense attorney begins questioning you. And before she really has a chance to get into the details of the facts of your case, she says, "Hey, Mr. Jones, did you review any records before coming in here to testify today?" And you know that the answer is yes, you did review some records. And now you are wondering, do you really have to answer that question? You're wondering what's going to happen to you in your case if you do tell her that you did in fact review some records. Will it destroy your case? Were you not supposed to look at certain records? I will tell you that your attorney should have discussed this with you prior to your question and answer session known as a deposition. Your attorney would likely have told you that anything you review in preparation for your deposition, the opposing lawyers would be entitled to see those things. So let's say you looked at your medical records. Now the defense attorney says, "Hey, did you review anything in preparation for today?" And you say, "Yeah, I went through my medical records. I had a copy of them that I got shortly after this occurred, and I wanted to refresh my memory about the dates that I saw the doctor." Okay, so now we would have to produce the copy of the records that you reviewed, and the defense attorney would want to see them to compare against her own doctor's records to make sure that they are the same set of records and make sure that there is nothing in there that has been removed or added. What if you went onto Google and did some research about your particular medical condition? Is that discoverable? Well, when the attorney asks you what you looked at in preparation for today, if you acknowledge that you did that type of online research, they will ask you exactly what you looked at, exactly what you found. They will ask what websites you looked at. They may even ask whether you printed it out and saved that information, or whether it is saved on your browser, on your computer, or your laptop, or your phone. Because at some point, they may ask for that electronic data. There are some instances where we actually have to turn over that type of information. The reality is that if you review any documents, any notes, any records about anything in preparation for your testimony, in preparation for your deposition, and you now disclose that information to the opposing lawyer, the opposing lawyer has every right to ask for copies of whatever it is you looked at. And then, what will they do with it? What they will do with it then is go through each and every page of the documents that you looked at and ask you many, many, many follow-up questions about every single document that you looked at. This is especially true if you have notes or diaries about the treatment, the care and treatment that you received, as well as any conversations that you had with various doctors. The defense would be entitled to not only see that, but ask you many, probably hundreds of follow-up questions about each and every entry that you have that you reviewed in preparation for your deposition. So getting back to the title of this video, will it destroy your case if you admit and acknowledge that yes, you reviewed some documents? The answer is no. However, the defense will be entitled to see and read and review any of the documents to which you acknowledge reading and reviewing in preparation for your testimony. So, going back to the question I raised in the title of this video, will it matter to your case if you acknowledge and say, yes, I did review these medical records, or yes, I did review these photographs? Okay, what photographs did you review? By counsel, here are 10 photographs of the incident, here are 10 photographs of the area that my client reviewed. Feel free to take a look at it and ask her any questions you wish. And that's exactly what we have to do. We have to give the defense an opportunity to question you about anything you reviewed in anticipation or expectation of your deposition. Now, what happens if you didn't review any records or anything in preparation for your deposition and only met with and spoke to your attorney to prepare you for the deposition? What happens then? Well, then you answer honestly and you say, no, I didn't review anything. I have no records to review. I didn't look at anything. Okay, fine. Now the attorney is then going to get into the details of your case, about your history, your family history, your medical history, and ultimately lead up to various questions concerning what brought you to this particular event that prompted you to bring a lawsuit. That's usually what happens in these medical malpractice cases, where the defense attorney will want to know, hey, Mr. Jones, did you review anything in anticipation or preparation for your testimony today? And by the way, when I question a doctor in a medical malpractice case, I will also ask a similar question or similar series of questions. Doctor, in preparation for today's deposition, did you review my client's medical records? And the answer is always yes. Did you review any subsequent medical records or medical treatment that my client received? Yes or no? If the answer is yes, I will then question him and learn what records he reviewed. In a death case, I will ask, did you review the autopsy record? Did you discuss any of these records with any physicians in preparation for today? Did you do any medical literature search or do your own online research about this particular condition? Yes or no? So not only does the plaintiff, the injured victim, have to answer those questions about whether or not he or she reviewed any records prior to testimony, but the same thing is true for the doctor as well. So why do I share this quick information with you? I share it with you because I have a few minutes to share as I walk along the beach, and I thought it would be helpful for you to understand how these types of cases work. And I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.